The original version of the model law in 1985 insisted that the arbitration agreement be evidenced in writing. It didn't have to be signed by the parties or contained in any exchange of letters or telegrams, as was required by Article 2.2 of the New York Convention. Nevertheless, it did provide a slightly restrictive formal validity rule that was then changed in 2006. The 2006 version of the model law gives countries two options. Option one requires only that there be a document in writing to which the parties have agreed. So option one means that if the parties have orally agreed to the written document, then you have a formally valid arbitration agreement. Option two simply gets rid of all formal validity requirements. Option one is based on the English approach to its arbitration acts, notably in the case of Zambia Steel, which said that an oral agreement to a written document was perfectly adequate. And that would certainly work for countries that have adopted option one. Option two has its origins probably in Sweden's dislike of formal validity requirements, and also the French case law adoption of the Swedish approach for international cases in the 1980s, which was then subsequently adopted into their legislation on international arbitration more recently. Frankly, formal validity requirements don't work. They don't protect the weaker party, because where a weaker party is manipulated into agreeing to arbitrate, there's probably going to be a signed arbitration agreement. And they don't even provide a great deal of certainty about whether there has been an agreement to arbitrate. Ultimately, they protect the wrong things, and they look a bit silly when, as happened in a case called Britannia and Jessical, the party suing on the contract is trying to get out of the arbitration clause that's contained in that agreement. You can see the ridiculousness of relying on one part of the agreement but not the other part. Ultimately, the Swedish nihilistic version, which is effectively adopted in option one as well, because it's very rare, even under English law, that you ever find a formally invalid arbitration agreement, is the way forward. And it makes a great deal of sense, frankly, for countries to adopt option two. This, though, creates some interesting problems, because under the New York Convention, you are required to produce an agreement in writing to get your award enforced. That requirement needs changing as well to bring it into line with option two of the model law.